A hearty good morning to all dignitaries, participants, faculty, and students. On behalf of Institute of Law, Nirma University, Ahmedabad, I, Singh, welcome you all to the virtual international conference on the theme of Language, Law, Literature, Dialogic Interfaces. This conference is a pioneering event for a project initiated by ILNU, which aims to develop library resources and pedagogical approaches in language, legal, and literary studies. We aim to explore the avenues and possibilities of conceptual and pedagogical enrichment through meaningful exchange of ideas and methods over the course of next 2 days. We hope that this project facilitates mutual understanding, critique, bridging of gaps in terms of pedagogy and practice. I would like to extend my heartfelt gratitude to all academicians and professionals participating in this conference for sharing their insights and experiences on diverse thematic possibilities. I would now like to kindly invite Director and Dean of ILNU, Professor Dr. Purvi Pokhariyal, to kindly deliver the welcome address and give an introduction to ILNU.
Thank you so much, Nainika. Respected Honorable Justice B.N. Shri Krishna, the conference convener, Dr. Bini, Dr. Kunal Kishore, and Dr. Kushal, all the students and the participants and paper presenters for this conference. It is indeed a matter of privilege for me to welcome Honorable Justice B.N. Shri Krishna, who is kindly accepted to be with us on this beautiful morning. When we talk about language, literature, and law, the first name that comes to my mind is Honorable Justice B.N. Shri Krishna, because Sir is linguist, basically knows so many languages, has interpreted the law and has a deep interest in the literature. And I just requested Sir kindly be with us and grace the occasion and give your insightful address, and he has kindly accepted. So thank you so much. We welcome you on behalf of Nirma University and students. Our Vice Chancellor, Dr. Anup Singh, was to join, but he had some last-minute medical emergency and has to rush to the doctor. He is not able to join. So I, on behalf of Dr. Singh, also welcome Honorable Justice B.N. Shri Krishna. Friends, this conference on language, law, and literature is as Nainika has rightly pointed out, is an initiative of series of deliberation that is going to take place in this area, and that we intend to have for establishing a center for law, language, and literature. Basically, what we envisage that the center would establish pedagogy labs, which will nurture and experiments of literature as a pedagogy, and for developing some of the most vital lawyering skills like critical thinking, creativity, analytical thinking, cross-cultural understanding, and the most important thing is human dealing. So when we talk about language of law, we all talk about its complexity, its clarity is required, a certainty of laws is required. And, when we talk about judgments also, we always been that much has been said and written and discussed about the language of the judgment, how lengthy judgments that we are all witnessing, and what we can do in order to make this judgments more accessible for the grasping by a common man. And it is also one of the significant facets of access to justice, because if the common man is not able to read the law, not able to read the judgment properly and understand it, the access to justice is somewhere compromised. So when it comes to the judgment writing, probably how an attempt would be carried out by the center, that how it should be more concise, how brevity can be maintained. In addition to that, how literature comes handy in interpretation and justification for some of the most complex issues of law and life. And I'm sure that with your all support, we would be able to accomplish some of these objectives in years to come. If we talk about literary legalese, we have had writers writing about the law or using literature as means to explain the law, or using law as means to explain society. And we have a number of judges who have resorted to literary legalese, including Honorable Justice B.N. Shri Krishna, to explain their arguments. So we, an Indian example, we have Justice Vivian Bose, and I recall a very famous judgment of Justice Vivian Bose, that BD Supply Company versus Union of India, wherein which was a complicated tax matter, and he elaborates that after all, for whose benefit was the Constitution enacted? What was the point of making all this pother about the fundamental rights? And he used the literature to explain the rights of the weaker section of the society. Same is, we all are aware about the judgments of Justice, the great judge, Justice Krishna Iyer. His judgment is at times is so difficult to read. The language is so complex and clumsy. But at the same point in time, Justice Krishna Iyer has always been using, at many occasions we have seen that he has been using literary text to justify and to put some emphasis on the interpretation that he intend to carry. And one of this case that comes to my mind is Maruram versus Union of India, wherein he has quoted Oscar Wilde. And, basically this case was, as we all know, is all about, granting the remission of the sentence. And then he used these lines of Oscar Wilde that I know, and I'm just quoting from this judgment, that I know that whether the laws be right or whether the laws be wrong, all that we know who lie in goal, and is that the wall is strong, and that each day is like a year whose days are long. So, and then he goes on explaining this thing that broken hearts cannot break prison walls, since prisons are built with stones of law, and the key to liberation too is in the law's custody. So, and he goes so on and so on, so on and so forth. And finally, he quoted Gandhi's Guru Henry David Thoreau, and he also said that the law will never make man free. It is man who got to make the law free. And this is how, time and again, we have seen that Justice Krishna Iyer has taken a help of literature. When we talk about, the law and literature movement, probably what we find is that the world over, there is a rise of law and literature movement, and which is, according to me, is a welcome affirmation of literature's relevance to a larger societal goals. And if we see some of the Western professors and academicians and thinkers who have worked on this area, we have Professor Richard Weisberg and Martha Nussbaum, and they both of them, they argued that the great literary works support the respective theories about the law. We also have Richard Dworkin and Stanley Fish, and basically the Dworkin advocates the application of the methods of literary interpretation to legal texts, and the classic book that we all had read in the jurisprudence and in the legal method. And when we talk about Stanley Fish, he proposes that both legal and literary texts should be seen ultimately as a rhetorical exercises. Same way we have Richard Weisberg, Richard Posner, when we talk about poethics. So basically, how do we develop the pedagogy of poethics? That is what our center, that is what the major goal of our proposed center. And probably, as I said earlier, when time passes, first of all, we will have all the library and literature resources as a part of the documentation in the center. Then some of the selected faculty members would use these some of the resources in each of the classrooms. So it's not something that when you're teaching English literature as a part of the course, you're using this all the material comes handy to you. Even when I'm teaching CRPC or whenever I'm teaching tax law, if I'm teaching constitutional law, if I'm teaching probably the environmental law, how I'm using this literature even to develop the ethical understanding, to develop the creative ideas. And then we are going to document these experimentations and reflections of these experimentation that we do in the classroom with the help of the students. So, I mean, I know it's a little bit ambitious goal, but with your blessings, with the blessings of Justice Krishna, Justice B. N. Sri Krishnan, and with all your support and cooperation probably in future, in few years, we are going to have, we're going to accomplish these objectives. With these note, I once again welcome Honorable Justice B.N. Sri Krishnan, the chief guest for today's function, and all the paper presenters. We have professors from different fields. You know, we have professors from law, literature, political science. They're sharing their views in different panels for in this conference. I welcome them all. Thank you very much.
Thank you so much, ma'am. Thank you for that introduction to the project. It couldn't have been put into better words. I would now like to invite Assistant Professor in English at ILNU, Professor Binny B.S., to give a thematic introduction to the conference.
Good morning, everyone. This conference on the theme Language, Law and Literature, Dialogic Interfaces is the event that marks the beginning of a project initiated by ILNU. And this project aims to develop library resources and pedagogical approaches in this area. We have already started enhancing our resources for the project by procuring books and subscribing to journals and database. The curriculum at ILNU focuses on language, communication, and related skills in the first semester, whereas in the second semester, it is a rigorous course in literature with focus on diverse politico-legal concepts. The idea about such a project and pedagogy came to life after a casual discussion with our director and dean, Professor Purvi Pokhariyal, who suggested that while we aspire to make the English course for law students more intense than a functional language training, we must also be clear about the conceptual and pedagogical innovations and implications. Professor Pokhariyal's contribution to this event has been valuable. There were many other inspirations behind the idea of this project. One is a letter by Judge Felix Frankfurter to a 12-year-old boy who sought his advice about going to law and the prior preparations required for that. The judge suggests that the child should read, listen to music, and look at paintings to develop critical thinking, nourish imagination, and foster the ability for experiencing moments in life vicariously. Choosing law as a career requires a cultivated mind, well nurtured by knowledge, ideas, and inventive thinking. Frankfurter's letter made us ponder upon opening up a dialogic space that brings together language studies, legal studies, and literary texts. We have used a term, mutual enrichment, to denote the benefits of such a convergence. Usually, a course in language and communication serves as a handmaid to many professional courses like engineering and management, and we wanted to do things slightly differently. For students of law, one has to look beyond the tangible benefit of better language skills from an English course. While it is important to have a persuasive style of communication and rhetorical skills, the primary aim should be to develop a habit of creative conceptualization, resourceful explorations, and critical inquiry. Literature provides narrative tropes and context to interpret and reinvent politico-legal concepts like equality, rights, justice, and the like. Bringing the experiential and affective into this inquiry, literature could also initiate an ethical and empathetic turn to legal norms, conventions, and practices. The intervention can lead to designing a novel pedagogical philosophy and method, and events like this could be a platform for sharing one's experiences, experiments, and innovations in pedagogy. The context and text of law can definitely benefit from the figurative, stylistic, and interpretative insights and innovations that language and literature bring to our cognition and expression. We hope the conference and our continued interaction with the participants would help us in many different ways. Primarily, this endeavor should help us in designing a pedagogical strategy that could put to use our new and developing collection of resources for a more perspicacious understanding of law as a discipline, practice, and system. It could also help us in developing a clear understanding of the potential benefits and desired outcome of the intervention through continuous trial and error and subsequent revisions and reorientations. Finally, it could help us in setting an action plan and goals concerning the degree and types of competency projected as the outcome of this intervention. We are eager to listen to the views of all the participants and resource persons concerning this project. I would like to express my gratitude to my team, Dr. Kunal Kishore, Professor Kushal Nandani, and our student coordinator, Nainika Singhal, for making this conference a reality. I thank all the participants. Thank you once again.
Thank you so much, ma'am. We're very grateful for having you at the helm of this project. I now have the honor of inviting the chief guest of this inaugural ceremony, Justice B.N. Shri Krishna. We welcome you, sir, and I invite you to kindly deliver your address to the audience.
Thank you, Nainika. Dr. Purvi, Pokhariyal, Dr. Bini, Nainika, Arpit Sharma, Amit Kashyap, Vishakha Gandhi, Surekha Talari, whom I can see on the screen, and many others whom I do not. A hearty good morning to you. It's always great to be in the company of academicians, because that way I can enrich my knowledge and my visions can be expanded. I will start from where Bini mentioned the incident of Felix Frankfurter. Just as Felix Frankfurter said this, there was a famous Chief Justice in England who was asked this question about what they would like, what he would like, what qualities he would like while recommending a lawyer or a barrister there to judgeship. He said the person should be well read in the classical literature, appreciate music, arts of various kinds, poetry, drama, blah, music, etc., etc. The interlocutor was puzzled, but he said, but Lordship, what about law? He said, a little knowledge of law also helps. So I belong to that category where I dabbled in various things and acquired a little knowledge of law along the line. I don't subscribe to all the good things that Purvi Pokhariyal was good enough to exaggerate about me. But I do confess that I have been fond of music, fond of literature, equally fond of law, and of course law has given me my bread, butter, and a lot of jam also. So let's talk more. You know, the interesting thing I must start by saying, this new thing about law and literature is not a new idea as far as the ancient Indian thinkers was concerned. The Indians have a very particular branch of knowledge known as Alankara Shastra, where what is known in English as poetics, the art of appreciation and critique of literature. A very famous Alankarika made a statement which is very relevant today also. He says, Dve Vartmari Giram Devyaha Shastram Kavek Karmacha. He said there are two approaches to the Lady Saraswati, who is the embodiment of all knowledge. One is through Kavya, that is literature. The other is through Shastra or any other discipline. Now, this was postulated way back in maybe 4th, 5th, 6th century. Now we come back to how this whole movement of law and literature has started and what is its purpose. Why is it necessary to encourage and develop its progress? The law and literature movement surfaced sometime in the 1970s, and by the 1980s, it gained sufficient momentum and recognition and became popular in the academia in the Western world. The law and literature movement focuses on the inherent connection between the two disciplines of law and literature. The movement was spawned basically for two reasons. One, by the growing doubts about the conventional theory of law, the Austinian theory of law, whether that is correct or not. And secondly, uh, and whether law in isolation can be a source of value and meaning, and secondly, whether it must be viewed against the backdrop of cultural, philosophical, and social science context to give it value and meaning. And finally, the increasing emphasis on the interpretation of all texts, whether literary or legal, based on literary and social context. This movement branched out into two distinct streams. One is known as the law in literature, that is where you understand enduring issues as they are explored in great literary texts. And the second was known as law as literature, where you understand legal text by reference to the methods of literary interpretation, analysis, and critique. The proponents of the law in literature theory were led by the famous American jurist and lawyer Richard Weisberg, about whom Purvi has just now spoken, who believed that literary works, especially narratives centered on legal conflict, will offer lawyers and judges a keen insight into the nature of law that would otherwise be missed in the traditionally strict study of legal rhetoric. Currently, this moment has become widespread with potential for far-reaching implications as to interpretations of legal texts, combining of literature's ability to provide unique insight into the human conditions through text with the legal framework regulating real-life human experiences. And it can give the judiciary a new and dynamic approach to reach the objective of providing a just and moral society, which law always is expected to do. Some scholars, such as Weisberg and Benjamin Cardozo, one of the brilliant judges of the United States Supreme Court, who were acknowledged both as novelists and poets, as well as legal giants, who were also teachers of law in the first half of the 20th century, became responsible for the genesis and spreading of this movement. Other scholars, such as James Boyd White, as well as the founder of the law and literature movement, because of the extensive research and publications he has contributed to this rapidly growing field. Famous among his many publications is the renowned publication known as The Legal Imagination, which is considered to have spearheaded the movement. This book was first published in 1973. It is a fusion of anthology and critique, almost like a traditional legal case book, but drawing inspiration from much wider and diverse range of sources, with annotations and headnotes emphasizing the relationship of legal texts to literary analysis and literary texts to the legal issues that they explore. In its early stages, the movement focused strictly on the law in literature theory. However, beginning in the late 1970s, the law as literature perspective began to expand and gain popularity. The latter seeks to enhance legal studies by examining and interpreting legal texts using the techniques of literary critics. Scholars such as White and Ronald Dworkin, to whom also Purvi referred, advocated greater relevance in law as literature because it maintains that the meaning of legal text, such as written law, like any other genre of literature, can only be discovered through interpretation, somewhat like our Mimamsaka's theories. The law in literature view is specifically concerned with the way in which legal situations are presented in literature. Such scholars have cited authors like Franz Kafka, Albert Camus, Herman Melville, Fyodor Dostoevsky, Charles Dickens, and of course our beloved Shakespeare in their support. Richard Weisberg, professor at the Cardozo School of Law, is another leading scholar of law and literature movement. According to Weisberg, there is justification for the theory in the legal arena because such novels cause their students to reach conclusions regarding human understanding. He coined the term poetics by combining poetics with ethics. for indicating an amalgam of poetics with ethics. Weisberg says poetics in its attention to legal communication and to the plight of those who are the others seeks to revitalize the ethical component of the law, and I quote. Law as literature scholars, however, see value in the techniques employed by literary scholars. They see legal text as a form of literature, thus making literary critique and analysis of it very much possible. Benjamin Cardozo was a proponent of law as literature. The success of Cardozo's books is also due in part to their distinction as literature itself. Convinced that style could not be separated from substance, Cardozo brought the judicial process to life in lucid, eloquent prose, spirited with humor, anecdotes, and practical allusions, which is his hallmark, just as we have Justice Krishna's hallmark in his judgments. Then we come to Ronald Dworkin, who also supports the arguments for the use of literature to improve legal understanding. In his article styled Law as Interpretation, Dworkin said, I propose that we can improve our understanding of law by comparing legal interpretation with interpretation in other fields of knowledge, particularly literature. He believes that our interpretations of literary works may help us to gain an improved understanding of our cultural environment, which in turn helps us to come to a better understanding and interpretation of the law. Adam Geary's Law and Ethics provides a discussion of aesthetics and ethics relevant to contemporary law and literature scholarship, which uses a range of points of classical literature from Sophocles to Shelley to Nietzsche to demonstrate the point that was being argued. Professor Ian Ward, Professor Melanie Williams are the two other well-known scholars in this field. Now we can't help noticing Richard Poskin, not because he advocated the school, but he violently criticized the field. Posner was somewhat like the Marxists, believed that everything revolves around economics. So according to him, law is nothing but economics refined into greater refinement. He played an important role in the law and economics movement, and not because he has been a severe critic of the law and literature movement. In his book, Law and Literature, A Misunderstood Relationship, Posner is highly critical of the law and literature movement, and the book helps to voice his more hardline interpretation of the law. Posner does not believe in the use of literary discourse in jurisprudential debate and describes West's analysis of literature in legal debates as particularly eccentric. Posner writes that law is a subject matter rather than a technique, and that legal method is the only method of choice in legal realms and not a literary one. Posner believes literary works have no place in judicial debate because one can have truly contemplate the original meaning of the author, and that novels should only be considered in their context. He characterizes the discovery of laws in fiction as ancillary and asserts that the main subject matter of the novel is always the human condition and not the legal setting. From this perspective, according to him, the legal background created by Kafka and Albert Camus, who are simply background, have no further meaning beyond the environment which they create. Highly critical of the notable law and literature scholar, Posner believes that such legal minds have taken literature too seriously and assigned to them an unsubstantiated amount of weight in the expansion of legal knowledge and jurisprudential debate. Finally, we have people like Richard Delgado and Jean Stefanczyk, who were against White in his theory of certain famous legal cases in US history and agreed with Posner on several issues. Their theory is that the actual impact of contemporary literature on the substance of judicial opinion making is limited because judges distinguish legal texts. According to Delgado and Stefanczyk, Judges' moral positions are determined by normative, social, and political focuses rather than by literature. They are firm believers of the critical race theory, which is a school of sociological thought that emphasizes the socially constructed nature of race. When we look at ancient Indian literature, we see that there is no hard and fast division of law and literature, as both seem to be inextricably interwoven. The various smritis of authors like Yajnavalkya, Brihaspati, Manu, Parashara, Narada, and others are brilliant pieces of literature, albeit prescribing normative social standards, which is exactly what a law is supposed to do. Ramayana, Mahabharata, Bhagavata, Bhagavad Gita, and a host of Puranas are both literature and law richly combined. Even poets like Kalidasa, Bharavi, Harsha, etc., in their masterpieces of literature, emphasize the norms of social behavior, exactly what the role that law would play. Works like Hitopadesha, Kamandaki, and Itsara belong to the genre of law, but are well known as literature also. This was possible because the objectives of literature, according to the scholars of Indian poetics, as typified in the famous saying of Mammata in his Kavya Prakasha, is where he enumerates the 5 objectives of literature and declares Kavyam Yashase Arthakrite Vyavahara Vide Shiveta Rakshataye Sadhya Paranirvritaye Kanta Sammitataya Upadesha Yuje. Meaning, roughly translated, literature is for attaining fame or glory, riches, transactional knowledge, to protect society from harm, and for ultimate happiness, all conveyed as if by the loving words of the beloved. Kanta Samhita is a very beautiful expression used in Sanskrit literature, meaning what is conveyed by a beloved wife, as opposed to Prabhu Samhita of do and don't, which is by the Vedas. Thus, for the Indian psyche, there was nothing novel or path-breaking in the movement of law and literature, nor was it considered necessary at all, as it believed in finding law in literature and literature in law. Combining the two tributaries of forensic rhetoric and literary critique, the Indian thinkers turned it into a mighty river of knowledge where the different schools they belonged to became immaterial. The ability to see unity in diversity is our forte, and I believe we should enhance it for the benefit of all humankind. I noticed from the program circulated that there are several papers being presented by well-known academics and scholars, which are going to be discussed and debated over the next two days, including today. My congratulations and best wishes to Nirma University, Dr. Anup Singh, Dr. Purvi Pokhariyal, Dr. Bini, and Nainika Singhal, and all the academicians who have helped in arranging this event. My best wishes for thumping success of the event. Thank you very much.
Thank you so much, sir. Thank you.
Thank you so much, sir. Thank you for giving us such a nuanced insight into our cultural and historical foundations of the intersecting study of language, law, and literature. We are truly, truly grateful to have you with us. I would now like to invite Assistant Professor in Law at ILNU, Professor Kushal Nanvani, to kindly deliver the vote of thanks for this inaugural ceremony.
Thank you so much, Nainika. A very good morning to all of you. Professor Justice B.N. Sri Krishna, Professor Purvi Pokhariyal, and all those present in the meeting. It gives me immense pleasure to deliver the vote of thanks. First of all, I would like to thank our chief guest, Justice B.N. Sri Krishna. Sir, I think your address has set the platform for the next 2 days. I think you've said some very important things that would help us and going forward. We'll keep in mind. Thank you so much for that. I would also like to thank Professor Purvi Pokhariyal for her address and for her constant support. I think she has been instrumental in organizing this conference, and without her support, it wouldn't have been possible. I would also like to thank my co-conveners, Professor Bini and Professor Kunal, for organizing this conference, for all the efforts that they have put in. And also the student convener Nainika Singhal. I think she's done a lot of hard work in behind the stage in organizing this conference. Lastly, I would also like to thank all my faculty colleagues and all the people who have sent in their papers, all the presenters who have sent in their papers. And we are looking forward to 2 very engaging days, 2 very interesting days full of interesting conversations. Thank you so much, everyone.
Thank you, sir. Thank you so much. And I think the whole plan is, Justice Krishna, that Bini is also going to compile some of the papers and has an idea to come out with the book. And we would need your support, and we would keep disturbing you time and again, because this is, as I said, is very ambitious thing, and you have such a huge rich experience in this area. We would definitely would like to take a piece of advice time and again from you, sir. Thank you so much for joining. Thank you. So Nainika, now we have the next session coming up.
Yes, ma'am. Now we will be devolving into the separate sessions that we are going to have for the course of these next 2 days. And we'll be, right after this, we'll be starting our sessions after a short break.
Okay.
Yes.
Thank you so much, and thank you for joining. Thank you.
We'll
Okay.
talk about it later. Thank you.
Yes. Okay.
Anika.
Bye-bye.